that Fifth Amendment has got a long heritage that goes way back. In fact, ancient Israel had elements in their law. We're going to talk about grand juries a little bit and about double jeopardy, which seems to have become rather common, much like it was anciently, well, at least during the royalty running this continent from England. We're going to talk about the sacred nature of private property and some of the perversions that are happening with this thing today. All right, this get together, we're going to talk about the Fifth Amendment. And it's interesting, probably to some people at least, it should be anyway, that Fifth Amendment has got a long heritage that goes way back. In fact, ancient Israel had elements in their law. We're going to talk about grand juries a little bit and about double jeopardy, which seems to have become rather common, much like it was anciently, well, at least during the royalty running this continent from England. We're going to talk about the sacred nature of private property and some of the perversions that are happening with this thing today. So we oftentimes bring up the Declaration of Independence. It is absolutely foundational in everything that followed afterwards. It was as though they had been writing the script without having all the details in it when they put it forward. They talked about the origin of rights, for sure, the purpose of government, the right of the people to change their governments, and the right of the people to start new governments. All of this stuff was embedded in what ultimately became the United States Constitution. So I put this little segment of the Declaration of Independence in here for the reason that I always like to emphasize the basis of the hope of the Declaration of Independence was the Westphalian Treaty of 1648. We're talking, I mean, this happened a long time ago before any of the founding fathers were born, and yet they talk about a separate and equal station, assuming powers of the earth. The Westphalian Treaty said there are no second-class nations. Every nation is sovereign and independent of all others. No one else can interfere with them. The founding fathers knew that if they could declare their independence, make it stick by force of arms, that they would join those nations of nations and be equals with those. So let's just look at this really quickly, and then move on. But all of these things are just incorporated so magnificently into the United States Constitution from the Declaration. When in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth, okay, that's out of the Westphalian Treaty. Separate and equal station, yeah, that's out of the Westphalian Treaty, to which the laws of nature and nature's God entitle them. You can read about that in stuff like Montesquieu and Blackstone and of course Locke. A decent respect for the opinions of mankind requires that they should declare the causes which impel them to the separation. Okay, these guys weren't just radical, burn to the ground individuals that wanted to throw a bunch of Molotov cocktails and hand grenades, then go home and just let things happen. No, they had a plan. They knew that they had to show the validity of the direction they were going. So they wanted to declare these things. Of course, the Declaration talks about created and creators, talks about inalienable rights. It talks about the purpose of government to secure those God-given rights, about the consent of the governed being required in order for a government to perform its labors. And whenever these things becomes contrary to this, the people can alter or abolish it. All of this still continues to exist and to institute new government. Now, of course, the idea of instituting new government was also incorporated into the United States Constitution in order to allow it to be done peacefully and in appropriate manners. So all of these things are there. Well, the founders went forward and they talked about all of the things that the king, not all, but many, 27 of the things the king was doing that were dedicated to despotism. And they said, it's our duty, it's our right to throw off this government. And then they indict the King of Britain. By the way, this is just an interesting side note. Nobody gets a free pass. The word of the king is not law. The king can do wrong. And the founders wanted us to understand that, and they wrote it into the Constitution also. We have the privilege of bringing about charges through, these things of showing that they've violated their oath of office, and then bringing charges on them, and then ultimately and finally, if they're removed from office, to bring them before courts of law for criminal charges to be carried out. So anyway, the American founders said, let's talk about some of these problems. Well, I'm not going to do a lot of them, but we're going to speak tonight about a few of them that were actually in the Declaration. And the Declaration, in my opinion, reads as though it were today's news today. The guy, the head of the government, was obstructing the administration of justice. He was depriving us of the benefits of trial by jury. This is an extremely widespread problem we have today. This idea of being transported beyond seas to be tried for pretended offenses, this happens still today in America, where they take people overseas in order to not be bound, in their opinion, by the United States Constitution. They've altered the forms of government that they've taken oaths to without really altering them. They just ignore them or set them aside. It goes on to say, a prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of a free people. I would submit that those people that are violating these things today need to be called to task also. So all of these things were brought together, as we said, under a United States Constitution. And we'll see afterwards here that the Utah Constitution is patterned very much after the United States Constitution in terms of recognizing limits and bounds in the areas that we're speaking about in this gathering. Noah Webster, one of the American founding fathers, created the first American dictionary, and in it he defines Constitution. And he says in it that the Constitution is paramount to the statutes or laws enacted by the legislature, limiting and controlling the legislature's power. What the heck does paramount mean? It means the Constitution is superior to all others. It's eminent, of the highest order. It's superior, and it is the highest in rank or order. Okay, so the Constitution is paramount. Any act of the legislature which contradicts the Constitution, or any effort by any department or branch to exercise a power not granted within the Constitution, is unconstitutional. And that means it's illegal, null, and void. And the more people that can come to understand that, the more opportunity we're going to have to bring corrections to the legislature, because at virtually every turn, they ignore the Constitution. In fact, we're going to, we'll see in a little while that let's take for the Utah Constitution, for example. It protects and preserves the right to private property. A long-time serving Utah legislature, a Utah senator in the Utah legislature, said the Constitution does not recognize nor protect the right of private property. And as we'll see very clearly in plain English words, it says it does. They do not read nor support, nor sustain, nor live by the constitutions they take an oath to uphold. Okay, so Tucker, again, I introduce him as the preeminent constitutional scholar of the founding era, talked about the Constitution, saying it's a written contract. Government was reduced to its elements, its object was defined, its principles ascertained, its powers limited and fixed. And of course, when they brought forth the Bill of Rights, they said they wanted to make sure that there were further declaratory and restrictive clauses added to the Constitution to make sure that in no way, shape, or form could there be any inference made that the Constitution granted a wider scope of power and authority than it actually did. And in fact, the 10th Amendment fully clarifies that and says, if we didn't give it to you at the general government level, you don't have it. Of course, the 9th Amendment says that we retained all other of our rights, even if it doesn't mention them. So it's an all-encompassing document to declare and restrict any usurpation by the general government. Okay, so as I said, we're going to talk about the Fifth Amendment. It requires an indictment by a grand jury before a person can be tried for serious crimes. It says there's no double jeopardy for the same offense. As we go through these, you'll find that they're ignoring these almost completely across the board. If you've gone through the trial process and found not guilty, you can't be charged again. unless the feds decide they're going to call this thing you did some other crime, and then they charge you with a federal crime in violation of the spirit and letter of the Fifth Amendment. You can't be required to self-incriminate yourself. Due process is required to take person's life, liberty, or property. It can't be an arbitrary, unilateral thing that happens because they have the power to do it. And if you do take private property, you have to pay the fair market value for that. Okay, so here's what the Fifth Amendment says. No person shall be held to answer for a capital or otherwise infamous crime, unless on the presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Okay, now we're going to come back and isolate that little segment about this land or naval forces and militia and war, and just comment peripherally about that, because boy, have we forgotten that one and why it's there. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Okay, this idea of an indictment by a grand jury. I did a radio program very recently where the topic came up, and I'll be gentle and kind. They thought that the grand jury ought to be held in public and that there should be basically a circus show done by it. And of course, it was involved with the grand jury things that was going on with former President Trump. Now, the American founding fathers were very, very, very sensitive to how destructive a charge can be, and to have to actually be charged for a crime and go to court and be held incarcerated for any period of time while it's being prepared or afterwards, it's a pretty heavy burden. And I'm constantly telling people that the entire American process, if there's a bias in it at all, it's biased in favor of the person that could be charged. And the intent for this was that they wanted to make sure that the evidence was examined before this became public, okay? And then that grand jury has got to issue a true bill that says, yeah, it looks like there's smoke, there's fire, we're gonna be able to charge this person. So before a person could be charged with a serious crime, the grand jury had to examine the evidence that the prosecutor's holding. And if evidence was true, it could indict the person, and then they should be arrested and charged. But all of this was supposed to happen so that if the jury came back and said, hold it, what the heck are you doing? You guys are on a witch hunt. Use whatever terms you want. But unfortunately, all too often, grand juries have become a rubber stamp. They give approval for virtually all requests that are placed before them. In fact, it's been in common use lately that in Manhattan, you could indict a ham sandwich, because all the prosecutor has to do is throw it before their rubber stamp grand jury, and yes sir, 3 bags full, they bring it forward. The grand juries, I don't know where they get them, but they just operate under this premise that, hey, the prosecutors wouldn't have ever asked for this if it was unwarranted and the evidence didn't fully support them. But of course, we're going to indict this guy. So, but the thing was that this was intended to protect the person that may be accused. So they did not have to suffer if it was simply, as we say, a witch hunt. So because arrest and trial, they're extremely embarrassing. They dramatically affect your life. Sometimes it puts your ability to even, provide for yourself. You might lose your job. You might have the job set aside while you're trying to gather evidence and help clear yourself, whatever. The founding fathers wanted to make sure that didn't happen. But all too often, the charged person is charged with very unsubstantiated and very flimsy evidence. We need to return to that process, that we do not allow these things to be railroaded through without substantive evidence that there's a good chance that there is a reason to charge the person. Let's go on to this little piece about except for cases arising in the land or naval forces of the militia or when actual service in time of war or public danger. This actually comes as a protection and a recognition, and it's clearly woven together that in the Constitution, Article 1, Section 8, clauses 14 and 15, they come into play on this. Here's what it says in clauses 14 and 15 in Article 1, Section 8. Congress shall have power to make rules for the government and regulation of the land and naval forces, to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. Okay, so if you had to take something before a grand jury in some state in regards to some action by a military force that really was under the jurisdiction of Congress, that would be a problem because there would be an overlap and a conflict potentially. And so because of this rule in Article 1, Section 8, clauses 14 and 15, Congress has power over the military forces. Now, this has a little side trip we could easily take. Make rules for government and regulation of land and naval forces. Isn't it interesting that the executive branch has decided that gender transitioning is totally appropriate, the bringing of people in that have those kind of challenges and incorporating them into the military, compelling the young women in the military to shower with these guys that think they're girls, or at least are playing like they do. All of this stuff is under the power of the Congress. The executive cannot arbitrarily and unilaterally say, oh yeah, these are the new rules of engagement for the military. No, Congress needs to reassert their power in this matter. And the founding fathers were so careful about this that in the Fifth Amendment, they looked back into Article 1 and they said, oh yeah, Congress has power to do certain things, and that's oversight of military. And so they incorporated that into it, and that's why that statement is made in the Fifth Amendment. Okay, nor shall any person be subject for the same offense to be twice put in jeopardy of life and limb. Double jeopardy for the same offense, having once gone through the trial process. Now, where this came into play was that prior to the establishment of the nation, the king often caused people who had faced trial, but there wasn't sufficient evidence to really convict them, to be rearrested to face trial on the same charges. And they did this over and over again, hoping that evidence would be found that would incriminate them. And ultimately, yeah, we could say, oh yeah, we justified, we've got him in jail, okay? The double jeopardy protection was included in the Bill of Rights to prevent this from happening here in this land, okay? Now, they've come around with a whole bunch of workarounds. Let's say, for example, you have committed some crime of violence against someone or whatever, and you're found not guilty. All too often, the feds step in. If they've gotta have a conviction, they step in and say, oh yeah, that action violated somebody's civil rights. Oh yeah, that's a good one. We'll do that. So they charge them again. Exact same action. Nothing is different. They were found not guilty in a given instance, and they've now charged them with a federal crime of the exact same everythings, and by golly, they get their conviction. Yep, justice has been performed, okay? Well, not so fast. We go back to St. George Tucker. He talks about the very guarded manner in which Congress are vested with authority to legislate upon the subject of crimes and misdemeanors. They are not entrusted with the general power over these subjects, but a few offenses are selected from the great mass of crimes with which society may be infested, upon which only Congress are authorized to prescribe the punishment or define the offense. Now, this is a really important sentence here. All felonies and offenses committed upon land, in all cases not expressly enumerated, being reserved to the states respectively. So all of these phony baloney charges and laws that are as expansive as the sun and the moon and the stars that are being put upon us. In fact, some time ago was cross-country skiing, and I ran across a sign. It was on federal land, and it said it's a federal offense to deface this sign. And I muttered under my breath as I went by, so what? Not because I'd ever deface a sign, but because everything's a federal offense anymore. They have made everything under the sun an offense that, as Tucker says, no, in all cases not expressly enumerated, they're only allowed in the states. We've got to do a lot of work to get that back again. Okay, now the Fifth Amendment also says that people can't be compelled in any criminal case to be a witness against himself, this self-incrimination process. So you can't be compelled to say, I'm guilty, okay? Now, ancient Israel had a similar protection in their judicial code. Now, I give you some references here in the beginning, and you can go look them up if you want, but I quote a couple of them here for your interest. And I want you to kind of keep in mind a couple of things as we go through this, because our Savior, Jesus Christ, was brought before an illegal tribunal to be tried illegally in an illegal place, under illegal circumstances, under illegal hours, under every aspect of it was illegal. And we're not going to take the time to deconstruct how that travesty of a trial happened. But you will find, as you go through a couple of scriptures here in a moment, that there were fundamental principles that were violated in this confession of guilt and the self-incrimination that had been around since basically ancient times. And so think about this, and we'll get to those scriptures in a moment. We have as a fundamental principle of our jurisprudence that no one can bring an accusation against himself. Should a man make confession of guilt before a legally constituted tribunal, such confession is not to be used against him. Now, you're going to find the only evidence they used to convict Jesus Christ is a self-conviction that was illegally elicited from him, okay? And then they say, unless properly attested by two other witnesses. Now, you might recall from that trial that for him saying, destroy this temple, and I will raise it up in 3 days, is far different from saying, I will destroy this temple, okay? So even the witnesses that supposedly were brought forth didn't agree to the charges, okay? Just kind of keep that in mind, go back and review that. We don't have time to make a full review of that travesty of a trial, but that's kind of the problem we have in many instances today. So here's another instance that talks about out of the ancient Hebrew law. Not only is self-condemnation never extorted, that means forced from the defendant by means of torture, but no attempt is ever made to lead him on to self-incrimination. Moreover, a voluntary confession on his part is not admitted into evidence and therefore not competent to convict him unless a legal number of witnesses minutely corroborate his self-accusation. So as we saw in the previous one, read at the bottom, two other witnesses have to have exact conformance to what that actually was stated by the individual as volunteering his confession. Okay, so the Savior's confession on the night of his illegal trial was used to convict him of blasphemy. Now, how can the one that talks about himself be accused of blasphemy if he's speaking of himself and it's truthful anyway? So it wasn't valid to be used against him. In this trial, Caiaphas, in violation of the prohibition against requiring any person to testify in his own case, except voluntarily and on his own initiative, demanded an answer from Jesus. And he also exercised his prerogative in his office of putting the Savior under oath as a witness before the court. So he compelled and he put him under oath. And then we'll see that he did something that violates even the law. I believe it was Leviticus chapter 21, I believe verse 10, talks about he's never supposed to rend his clothes. At any rate, so in Matthew we read, but Jesus held his peace. And the high priest answered and said unto him, I adjure thee by the living God that thou tellest whether thou be the Christ, the Son of God. I mean, they knew exactly what they were accusing him of. Jesus said to him, thou hast said, and that can be said to translate, I am what you've said. Nevertheless, I say unto you, hereafter ye shall see the Son of Man sitting on the right hand of power and coming in the clouds of heaven. Then the high priest rent his clothes, again, in violation of what they claimed to be the law. But there's a couple of extra scriptural places, like in Josephus, and I think the Maccabees also said that under extreme cases, you could tear your clothes, okay? The high priest rent his clothes, saying, he hath spoken blasphemy. What further need have we of witness? Behold, now ye have heard his blasphemy. What think ye? And they answered and said, he is guilty of death, meaning he's worthy of being put to death. In Mark, we read, but he held his peace and answered nothing. Again, the high priest asked him and said unto him, art thou the Christ, the Son of the Blessed? And Jesus said, I am. And ye shall see the Son of Man sitting on the right hand of power, coming in the clouds of heaven. Then the high priest rent his clothes and saith, what need we of any further witnesses? Ye have heard the blasphemy. What think ye? And they all condemned him to be guilty of death. Okay, so this self-incrimination thing, it also invalidated anything that was obtained through torture, either in ancient Israel or in modern America. And these kinds of things, I wish there were time to tell you what some of the things that happened under George Bush's administration that completely validated the use of torture, how they so narrowly defined torture that anything short of putting one of the accused children to death could not be accused of torture. Anyway, we have strayed far. We have become brutal and uncaring, and we could give scriptural evidence about how it was handled anciently, but not in time. We'll just move ahead. Okay, nor be deprived of life, liberty, or property without due process. This due process is required to take life, liberty, or property, and its original intent was to protect a person's life, liberty, or property from arbitrary heavy-handedness by government. It required a full hearing, a fair hearing, to review all the matters. Okay, so historically, the courts were called upon to review and figure these things out, but it's often become the practice that some other organization may do that. And I suggest here a department of the executive branch. And we can use as many examples, the IRS, for example, where they create the law. Well, they say it's not a law, it's a policy, or it's a rule, or whatever. And then they adjudicate it, and then they punish it, okay? And so they enforce, and at every level, it's in one branch. Now they say you can, when you get through the whole process, if you really want to, you can take it to court. By then you're drained of all capability of doing so. But the Bureau of Land Management, under Utah law, if we get the federal lands back, will be a division of land management that creates the law, if you will. It enforces the law, and it adjudicates the law. And some people would say that's kind of self-serving. You review your own actions, and it really puts the individual at risk, and he can't get it done because the financial resources are drained by the time all of the things been through the process that they've outlined. It really is a complete violation of this. And it's really hard to get something through the jury process too. We'll talk about that in another presentation. We'll go to Federalist number 47, James Madison. The accumulation of all powers, legislative, executive, and judiciary, which is what these organizations are, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. Okay, big, terrible amount of violation of that constantly in the application of every aspect of how property is handled and justice is not carried out. Going on with the Fifth Amendment, nor shall private property be taken for public use without just compensation. You got to pay a fair price for the property. You got to pay full market value to the individual losing the property. Now, many recent takings. Now we could talk about, let's just think about what happened in our legislature. The idea of emergencies being declared arbitrarily, unilaterally by an executive, and taking away private property, water rights, for example, and we'll find that they don't even allow for just compensation. They legislatively say, oh, here's the maximum amount you can take. And it is far below what would be a just compensation. So legislatively saying, oh, we're making this just compensation does not make it just. And it does not keep with the spirit and letter of what is in the Constitution, both in Utah and in the United States Constitution. We'll review those things very briefly in just a few moments. At any rate, we're going to talk about something that, you talk about special districts, you talk about purposes for taking water in order to be able to restore a lake or to allow mining to occur there that's very water intensive for, say, some precious mineral that's there or something like that. Or even to improve tax collections from municipality or private developers that could develop a project for profit. I use as an example something that happened. It was decided on a 5-4 decision in June of 2005. Kelo v. City of New London, Connecticut. Complete travesty, miscarriage of justice. The Supreme Court should have ruled differently on it. It did not. We'll talk about it briefly. This eminent domain seizure was to be happening. They were going to transfer land from private owners to another private owner. There was like 91 acres on beachfront property that were in question that had been owned by private owners for generations. And the city was going to seize it and give it to another private developer. They justified this in saying, well, the city's going to get some real tax-based benefit from this, so we'll all be better off. Supreme Court said that the takings clause, private redevelopment, are permissible under public use. Well, so the private property was condemned by the city of New London, Connecticut. It was to do a comprehensive redevelopment plan. They're going to put a big resort on the 91 acres. It was going to put a huge economic boost into the community. Okay, said, it doesn't violate, court said this doesn't violate the public use clauses of the state and federal constitutions. And what the court held was that if the legislative bodies found that an economic project will create jobs, increase tax and other revenues, revitalize a depressed urban area, it's a public purpose and it qualifies as public use. So they decided it's not unconstitutional for the government to take private property from one individual or corporation and give it to another if the government does so because the repossession puts the property to a use that would generate higher tax revenue. Now think for a moment about the worst case scenario. You have a church that does not pay any taxes. So if you seized it and put it to a public use, it would be an infinite amount of increase because there was nothing to begin with. Think about that. It's kind of scary. Okay, so when the city of New London won, they said they're going to charge the residents of the homes for back rent for 5 years since they'd begun the condemnation process. So now, adding insult to injury, they're going to say that you owe tens of thousands of dollars of rent to them for squatting on their property. Okay. Now, what they were going to do is give the redeveloper 91 acres of waterfront for $1 per year from the city. They thought that was a great deal because all the taxes they'd bring in, but the developer couldn't obtain financing. The project was abandoned. The property is a vacant lot. No tax revenue is generated for the city. And back in 2011, the New London redevelopment area was turned into a dump. That's because they didn't have a place to put all the trash that got blown around during the hurricane. So it cost the city $78 million, which I'm sure would be adjusted dramatically upwards nowadays. And there was a lot of public reaction to this. It was very unfavorable. And Bush issued a restrictive executive order. Congress considered some kind of legislation, never got around to it. But 44 states, as best as my investigation can tell, now have passed laws limiting seizure of private property for private development. Well, you might ask, what about Utah? Well, it's interesting. The state was in front of everybody, really, before the Kelo decision, that they removed eminent domain as authority for blight. So they were kind of on the right curve. But after the Kelo decision, the state became the first to roll back reform by reinstating a more limited blight authority and allowing condemnation by what? A neighborhood majority vote? You can have your property seized? Are you kidding me? This is absolutely absurd. Okay, so where did all this come from? All this nonsense about how they could do this. Socialism, reduced to its simplest legal and practical expression, means the complete discarding of the institution of private property by transforming it into public property and the division of the resultant income equally and indiscriminately among the entire population. So said George Bernard Shaw, one of the preeminent socialists of the Fabian flavor. Of course, in the Communist Manifesto, which was released in 1848, they have a number of statements also about private property. These are a few excerpts. When it says their mission, meaning communists, is to destroy all previous securities for and insurances of individual property. In this sense, the theory of the communists may be summed up in the single sentence, abolition of private property. That's one sentence. So if our legislature is saying they're going to seize private property for whatever reason, they have taken that single sentence definition that would say they're making communist overtures. Here going on in the Communist Manifesto, you're horrified that are intending to do away with private property. You reproach us, therefore, with intending to do away with the form of property, the necessary condition for whose existence is the non-existence of any property for the immense majority of society. In one word, you reproach us with intending to do away with your property. By the way, they talked about this way too about marriage and community of women and all that kind of stuff. They just wanted, it was a free-for-all on a lot of things. That is just what we intend. The communist revolution is the most radical rupture with traditional property relations. This cannot be effected except by means of despotic inroads on the rights of property. Okay, now you are all aware of the 10 points of the Communist Manifesto. These don't, it's not like they say, check these off in order and you'll have communism. No, these are how they're going to bring about communism throughout the world. We won't go through these 10 points, but you will look at 5 of them deal with abandoning or seizing or whatever you might want to call private property. Half of the 10 points of the Communist Manifesto have to be brought into effect in order to have full-blown communism. There was a guy back in France, loved the American founding fathers. He had only 2 brief, well, they're not brief, they're griefs with the American founders. They hadn't solved the slavery issue, and they had a mess on their hands with tariffs. Anyway, those are some longer discussions. But he was a political economist, a very prominent man. He wrote quite a bit about these kinds of things. In 1850, authored The Law to Counter Communism. This book, The Law, is required reading for absolutely every member of my family. You should review it regularly, and it's such a little document that you can read it in one sitting if you chose to do so. We'll take a few quotations from that. Life, liberty, and property do not exist because men have made laws. On the contrary, it was the fact that life, liberty, and property existed beforehand that caused men to make laws in the first place. What then is law? It is the collective organization of the individual right to lawful defense. Each of us has a natural right from God to defend his person, his liberty, and his property. These are the 3 basic requirements of life, and the preservation of any one of them is completely dependent upon the preservation of the other 2. For what are our faculties but the extension of individuality, and what is property but an extension of our faculties? Every person has the right to defend even by force his person, his liberty, his property. Then it follows that a group of men have a right to organize and support a common force to protect these rights constantly. That's what government is about. And we're going to see that others have agreed with this previous to Bastiat. But this individual right, protection of that which is ours, is why we have government. Based upon the time, I'm going to probably not read out loud these issues. You need to understand that Bastiat understood that when we made legalized plunder through the legislative process, that the police became the enforcers of plunder. And he at one point calls the gendarmes the enforcers of the plundering. And when those of us, and I think probably most people that are participating in this, find themselves in the group that wants to stop legal lawful plunder, but many are obviously in office and hold positions there that would try to expand legal plunder. He says this is a very dangerous thing. It's a perversion. And we lose, as I said in the final lines of this, when this happens, we lose the distinction between justice and injustice, because the law, which is supposed to be just, now becomes the enforcer of an injustice. So we need to abolish the law that's like this if it ever comes before us. Take the time to read Bastiat. It is a magnificent review of some principles that are absolutely Americanist. The 10 Commandments, 20% of them deal with private property. Thou shalt not steal. Thou shalt not covet. And it's expansive. Talks about your neighbor's wife, his servants, his ox, his ass, or anything that's yours. And coveted is desire inordinately, that which is unlawful to obtain or possess in a bad sense. That's how Noah Webster said it. But you know what's interesting? You make it legal, and people think that it's now right. And that's what we're doing constantly through our legal process, our legislative process. John Locke talks about how through work, you take something out of nature and it becomes your property because it's the labor of your body and the work of your hands. So nature provided it, you mixed in your labor, and it becomes your property. That's in its most basic genesis, if you will, of how private property came into being. And it says that supreme power, meaning the government, can't take this property, a man's property. And that's why people go into society and into create governments. It requires that the people shall have property. That's the whole basis of the purpose of government. Blackstone, read by the American founding fathers, and all of them studied him diligently. The things that are primary in the rights of Englishmen is personal security, personal liberty, and the right of private property. These are absolutely fundamental to being able to have a free society. And he talks about this, about free use, enjoyment, and disposal of his acquisitions. And this is what government's about. So great, moreover, is the regard to the law for private property that will not authorize the least violation of it, not even for the general good of the whole community. Think about what Utah did when they created the law that says, if you own an apartment, you must rent to people that you may not want to. But the law says you have to, if they have a definition based upon intimate behavior. And you have to do it. Of course, the churches, they just basically protected themselves from having to do that. Okay, let's go on to John Adams. He says all men are born free, natural rights, essential, inalienable rights, and it's acquiring, possession, and protecting property. That is a big part of seeking, obtaining their safety and happiness. The Declaration of Independence talks about these rights being secured. Adams said, property is a right of mankind is as real as liberty. The moment the idea of admitting into society that property is not sacred as the laws of God, and that there is not a force of law and public justice to protect it, anarchy and tyranny commence. As in when Utah decided that people that owned rental property had to rent, in violation of Article 1, Section 10 of the United States Constitution, in regards to interfering with contract rights, right? Hamilton said a power over man's subsistence amounts to a power over his will. He said it again, a power over a man's support is a power over his will. Private property cannot be taken for public use without just compensation. This is the last founding father statement, and then we'll go quickly into what Utah's Constitution says, and we'll be done. He said, government is instituted to protect property of every sort, this being the end of government. Yeah, this is why it's there. That alone is not a just government, nor is property secure under it, where the property which a man has in his personal safety and personal liberty is violated by arbitrary seizures of one class of citizens for the service of the rest. Think about it, whether it's a rental agreement or whether it's a private property right for water, or whether it's the withholding of private property by a division of land management that controls it in perpetuity. It's all on the socialist end. You compare and contrast what the American founders said with what those scurrilous bandits that wrote the Communist Manifesto said, or that tried Fabian socialism or whatever. It is, private property is not protected. Now let's look at the Utah Constitution very briefly. I remember a very prominent, long-time Utah senator said, no, the Constitution in Utah doesn't protect property. All men have the right to acquire, possession, protect property. Constitution of the United States is the supreme law of the land. No person deprived of life, liberty, or property without due process. This is a court thing. You can't just have an organization decide they're going to do it and not have any checks and balances. This idea of indictment by a grand jury is not as well protected in Utah as I would like to have it seen, because the grand jury is kind of at the beck and call of the legislature, and they have not been very good at preserving the blessings of liberty in this land. Okay, private property shall not be taken or damaged for public use without just compensation. Just compensation is not legislatively created. You have to look at what the market is paying for that. And that's far cry from what Utah legislature has been bringing out. Here's Article 1, Section 26. The Constitution is mandatory and prohibitionary unless express words that are declared to be otherwise. Okay, where do those express words come? Can they just make them up in legislation? Can the governor just say it? Or is it the actual wording of the Constitution? In Article 6, Section 30, we have the emergency use, continuity of government in case there's some big bad thing that happens in there. And let's read in Section 2 of it, subsection 1, does not permit these temporary public officers to act or these temporary measures to be contrary to the Constitution and applicable law. So you cannot violate the Constitution even in emergency. Again, remember, Constitutions paramount to the statutes or laws, and so they're superior to them, preeminent. And so a Constitution is paramount, and anything the legislature does contrary to that does not granted in the Constitution is unconstitutional. So there's how you get in touch with me, and next time we'll get together, we'll talk about the Sixth Amendment. Hopefully you'll be able to be back for that. Till then, take care.